Okay, let's dive right into this explainer. You know that massive, incredibly complex deck of paperwork you sign at a real estate closing? Well, today we're going to demystify it by focusing on the absolute core of the whole deal, the ultimate bridge connecting a pile of debt to real physical property, the security instrument. If you've ever bought a house, you know you sign what feels like a literal mountain of documents. But hidden in those pages is a very specific legal framework working behind the scenes. Our goal today is to break down exactly how a simple promise to repay a loan gets legally anchored to the dirt and bricks of a property. To make this dense legal framework a bit more accessible, we've structured this explainer around 5 key pillars. We'll start with the promise versus the property, move into identifying exact collateral, look at the borrower covenants, tackle default and acceleration, and wrap it all up with foreclosure and remedies. Let's jump right into Section 1, the promise versus the property, and lay down what we call the clean rule. So look, this perfectly illustrates the ultimate dichotomy of your loan docs. You've essentially got two sides. On one side is the promissory note. Now the note is just a personal promise to pay. It basically says, hey, I promise to repay the money, and it lays out your interest rate and payment schedule. But then on the other side, you have the security instrument, which, depending on your state, might be a mortgage, a deed of trust, or a security deed. This document says this specific property secures that promise. The note answers who promised to pay, while the security instrument answers what property actually backs up the promise. It's the piece of paper that gives that personal promise its teeth. Grounding this in some high-stakes reality, the Consumer Financial Protection Bureau makes it explicitly clear just how powerful this document is. It's the exact mechanism dictating whether you get to keep your home or lose it. The security instrument isn't just some glorified receipt. It's the actual legal right that the borrower gives to the lender to take the property by foreclosure if the terms aren't met. Now that we know what it does, let's move to Section 2 and see how it anchors to the physical world, identifying exact collateral. So the crucial point here is that in mortgage transactions, the real property itself serves as the collateral. You probably already know collateral is the tangible asset pledged to secure a debt. But what's really fascinating here is that legally identifying that real property requires a whole lot more than just knowing how to drive there or dropping a pin on your GPS. See, while a property address is great for helping the mail carrier or the pizza guy find your house, the legal description is what identifies the property within the county land records. We're talking lot numbers, plot maps, precise boundary lines, and here's the kicker. If this legal description is wrong, incomplete, or doesn't match the deed, the entire bridge connecting your debt to the land fractures. Seriously, a bad legal description can create massive title defects and completely halt a lender's ability to enforce their security interest. The devil is absolutely in the details here. Building on that foundation, let's look at Section 3, the borrower covenants, or the rules for crossing the bridge. What's truly wild is that the security instrument isn't just about naming the collateral. It's actually packed with ongoing promises made by the borrower, which are known as covenants. Yes, obviously there's the promise to make your monthly payments, but you're also legally binding yourself to pay property taxes, maintain hazard insurance, and literally keep the property from deteriorating. That's known as preservation and maintenance. Think about it. If the property rots away, the collateral loses its value, and that directly threatens the lender's security. There are also occupancy rules, like having to live there as your primary residence for a bit, and due-on-sale clauses that stop you from just handing the house and the loan over to someone else without the lender's say-so. Oh, and we absolutely cannot forget riders. You'll usually see these attached at the very end of your document stack. These are specific add-ons for things like adjustable rate loans, condos, or planned unit developments. And listen, they actually modify the core rules of the security instrument. They are not optional reading just because they sit at the back of an exhausting closing packet. They are legally binding modifications, which means, yep, you've got to read every single page. All of this leads us to a massive high-stakes question. What exactly happens if a borrower fails to uphold any of these strict covenants? What happens when the bridge starts to crack? That brings us to Section 4, default and acceleration, which is when the bridge fractures and the legal machinery kicks into gear. We constantly hear that defaulting simply means missing your monthly payments. But surprisingly, default can actually be triggered by a whole host of things. Forgot to pay your local property taxes? That's a default. Transferred the property without authorization? Default. Let the roof cave in and the property fall into severe disrepair? Yep, that's default too. Even lying on your original loan application can pull the trigger. It is so vital to realize that breaching any of those borrower covenants we just went over can throw the loan straight into default status. Now, once a default is officially established, and after any required warning notices are sent out, the lender invokes a really powerful mechanism called acceleration. And it is exactly what it sounds like. It pulls that entire 30-year timeline all the way forward to today. The lender essentially declares that the full unpaid principal balance is no longer due in 3 decades, it's due right now. The installment plan is officially canceled. For our final pillar, let's map out the ultimate remedy for when acceleration fails to produce the money. Section 5, Foreclosure and Remedies. You know, foreclosure isn't just standard debt collection, it's the strict, step-by-step enforcement of the security interest against the real property itself. As we've mapped out here, it moves very predictably. It starts with a default, moves through the required notices, which usually gives the borrower a chance to fix the issue, then advances straight into acceleration and concludes with a foreclosure sale. It's the harsh realization of that CFPB quote from earlier, the lender exercising their absolute right to take the property to satisfy the broken promise. Now, in a lot of states, particularly those using deeds of trust instead of traditional mortgages, this foreclosure process happens through a power of sale clause. This is a highly specific provision that lets a designated trustee sell the property without dragging everyone through a full drawn-out lawsuit in court, assuming state law allows for it. But make no mistake, it's not the Wild West. Trustees can't just do whatever they want. They have to strictly follow state statutory procedures regarding notices, publication, and mailing. It's a precise contractual and statutory enforcement path. Definitely not a shortcut around the law. While all of this is happening, the paper trail is absolutely critical. Security instruments are typically recorded in the county land records. Recording this powerful document gives the public notice of the debt and locks in the lender's priority against other claims. But, and this is a huge but, simply recording a document does not automatically fix its defects. If the legal description is completely wrong, or a signature was forged, or a notary acknowledgement is missing, recording it doesn't magically make it valid. It only provides notice. It's not absolute proof of validity. Finally, let's bust a massive myth that catches a ton of property owners off guard. The myth? Simply paying off your 30-year loan magically erases all the paperwork. The reality? It absolutely does not. If the required release, satisfaction of mortgage, or deed of reconveyance isn't officially recorded in those county land records we just talked about, that old security instrument will just sit there indefinitely, clouding your title. The bridge doesn't just evaporate because you paid the toll. It has to be legally, officially dismantled. So I'm going to leave you with this final, provocative thought to investigate regarding your own real estate journey. If your loan is fully paid off tomorrow, whose job is it to ensure the public record is actually wiped clean? Does your lender just do it automatically, or do you have to chase them down to make sure your title is actually free and clear? Understanding this bridge between debt and property isn't just legal trivia. It is literally the key to truly owning your home. Thanks for exploring the foundation of real estate security with us today.